Good afternoon or good morning. I would like to welcome everyone listening into today's webinar, 10 Solutions, to Corporate Immigration Challenges. We have a packed presentation today, but first I would like to go over a few housekeeping items. This webinar is being recorded, and we will send you the recording after the presentation concludes, so please check your inbox tomorrow afternoon for a link to download the recording and the slide deck. This webinar will last for about 45 minutes, and that includes a question and answer session. And if you would like to ask a question, please do so using the GoToWebinar function on the right-hand side of your webinar screen. All right, so first, I would like to introduce today's presenter. Jacqueline Pettit is an associate at Global Immigration Associates, PC. Jacqueline received her JD from DePaul University College of Law in 2012 and a BA in Communications Law and Policy from the University of Michigan in 2007. Ms. Pettit focuses on employment-based non-immigrant and immigrant petitions. Prior to joining GIA, Ms. Pettit worked as a prosecutor with the City of Chicago Department of Law, where she gained extensive administrative law experience. Jacqueline is licensed to practice in Illinois and is a member of the American Immigration Lawyers Association. Jacqueline, thank you for joining us today.
Thank you.
Great. So before I hand it off to Jacqueline, I just want to talk a little bit about Envoy. For those that are unfamiliar with Envoy, for nearly 20 years, the company has been on a mission to fix the frustrating, confusing, and inefficient immigration process. We combine expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in 150 plus countries, grown 46% year to date, and we work with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. All right, now I would like to turn it over to Jacqueline, where she's going to dive into today's immigration challenges and those solutions.
All right, hello everybody. So we're going to get into some of the challenges over the past few years that immigration attorneys, employers, and foreign nationals have noticed, including increased complexity in the immigration process. Lately, it's becoming more and more difficult to keep up to date on compliance requirements, documentation requirements, and changing immigration policies. Other challenges that employers are running into are longer processing times with the government, lack of visibility into the immigration process, inefficient data collection and document storage issues, and subpar security measures. All of these which can lead to increased employee anxiety and frustration for the employer. So we're going to go through these challenges in more detail. All right, so the first challenge we're going to discuss is the increased scrutiny of applications. Especially the USCIS is giving increased scrutiny to petitions filed, making it more difficult and stressful for employers and foreign nationals in the immigration process. The increased scrutiny that the USCIS is giving to petitions makes it extremely important for employers to make sure applications and petitions are prepared thoroughly and on time. As an immigration attorney, we suggest having strong job descriptions in place that clearly outline technical duties and minimum requirements for positions, and have a clear plan in place for responding for requests for evidence, which are being issued at alarming rates. Have a policy in place for who is responsible for gathering this documentation, and have documentation readily available so we can speed up response times after an RFE. You should also have clear document storage procedures to keep employee files easily accessible. All right. Some solutions to the increased scrutiny for applications. Again, is to keep documentation handy and well organized, So it's easy to track expiration dates, extension deadlines, and employee job descriptions. Have a clear policy in place to track employee travel, so employees can keep you updated on their expiration dates. A lot of employees don't realize how important it is to keep the company and an immigration attorney updated on their travel, as their expiration dates can change upon their re-entry, as the I-94 is updated every time an individual re-enters the U.S. after foreign travel. Technology such as Envoy can help a company and the foreign nationals track expiration dates and reduce the risk of anything falling through the cracks. You can store your documentation centrally, have centralized communication, and provide employees with transparency through the process. All right, another challenge, which you're going to see as a trend throughout this entire presentation, is employee fear and anxiety. 42% of employers have reported an increase in employee anxiety and questions surrounding the immigration process, especially under the current administration. This is due to policy changes under the current administration and lack of transparency through the hiring process. Some solutions that can help employers ease fear and anxiety amongst their foreign national employees would be to make sure the company has a clear and efficient onboarding plan for hiring foreign national employees. Again, including clear job descriptions and compensation details, points of contact, who's responsible for collecting documentation, and clear expectations for timelines and risks involved in the process. It's really important. I always stress setting expectations for hiring managers and recruiters so they're aware of procedures for hiring foreign national employees, such as timeline issues. If you're hiring an H-1B worker and they have to change employers, they're not going to be able to start the following Monday. They have to follow certain timelines to get the petition filed. All right, another challenge, subpar security measures. Employment and immigration files contain very sensitive information, and it's important to have measures in place for disseminating and storing information and documentation. Email is not a secure form of transmitting sensitive information. A solution would be to store and share the data in a centralized location. Create needs-based access, so make sure that only certain people within the organization have access, and only the employee has access to their specific information. And then let employees upload their documents directly when required for their application or petition. And again, immigration technology can assist in helping store this information securely and allow secure communication about the process. Another challenge is lack of transparency in the immigration process, including requirements for petitions, timelines for preparation and processing. This can all cause frustration for both the foreign national and the employer, leading to increased questions and anxiety. A technology platform such as Envoy can allow employees, HR, and attorneys to track cases, send alerts about expirations and deadlines, and increase communication speed and efficiency. You could track communication in a central location instead of having to keep track of multiple email threads. The next challenge is the confusing and complex immigration process. The immigration process is overwhelming for employers and employees. There are policy updates that are hard to keep up with, especially under the current administration, such as new document requirements, deadlines, and different expiration dates. For example, for a lot of non-immigrant employees, such as H-1B employees or L-1 employees, there are different expiration dates for their I-797 approval notice, their I-94 arrival departure record, and their visa stamp. And it's important to make sure those are all tracked properly. Again, a solution to easing concerns about the confusing and complex immigration process is having a clear immigration policy within the organization and setting expectations about document requirements and timelines, informing foreign national employees about their responsibilities, such as the documents they're required to provide, and reiterating that they should inform the company and or the company's immigration counsel about their travel dates, check their I-94 records upon re-entry, and keeping up to date about expirations. And again, technology can help the company and the employees keep informed of the important expiration dates and track upcoming issues. Another challenge, and perhaps one of the most frustrating lately, is the slow case processing time. Changes in security regulations and other policy changes have led to slow processing of petitions and applications filed with the USCIS and the Department of Labor, as well as delays in visa processing through the Department of State, which again leads to increased anxiety for foreign nationals. Some solutions to help cope with these slow case processing times. First would be to make sure to allow for sufficient time for processing petitions filed with the USCIS especially. For example, H-1B extensions can be filed 6 months before the employee's current H-1B expiration. So it's important to get open the case up early and get the LCA filed as soon as possible, so we don't run into any expiration dates while the USCIS is taking 5 to 8 to 9 to 10 months to process an extension. For change of employer cases for H-1B, make sure to set expectations for processing times and to get the case opened as early as possible so the LCA can be filed. And to do that, just make sure to collect up front a clear job description, job location, and salary, and pay attention closely to upcoming visa expirations. We recommend looking forward about a year to track upcoming expirations. You can forecast when cases need to be open to make sure that you don't run into any issues with missing an expiration date. And again, centralized visa organizers through immigration technology such as Envoy can streamline this whole process and help keep track of all of these expirations so we don't miss any of those important dates. Okay. Another challenge is compliance. Site visits from the USCIS and the Department of Labor are on the rise, and many of these site visits can be unannounced. So it's important to have a plan of action in place for a potential site visit. Make sure to establish a clear chain of command and a point person for taking care of a USCIS or DOL officer who may arrive. So make sure if you have reception or anybody who may be in the front of the office knows who to direct that individual to. Because you don't want anybody speaking to them who doesn't know exactly what's going on and giving them incorrect information or information that could harm the company. And keep the documentation in a centralized location so it's easy to access if you are to run into a site visit issue. And again, using immigration technology to self-audit can assist with compliance, as you can store the documentation centrally and easily access it for the USCIS or DOL officer. Excuse me. Another challenge is communication. In the onboarding phase, it's important to set up clear guidelines and processes for collecting necessary documentation and information, such as job description, salary info, reporting structure, employee education and maintenance of status documentation, etc. And it's best to make it clear who is responsible for collecting the information and who it should be reported to, and where the documentation should be shared. Immigration technology, again, can help streamline and centralize paperwork and communication surrounding the immigration process for your employees. Another challenge is increased competition for international talent. There is a lot of competition for, especially skilled technology workers. So in order to remain competitive in the marketplace, it's important to frame a corporate immigration policy that thinks about policies that will make the company competitive. I think one of the most important things that foreign national employees look at when changing employers or signing on to a new employer is green card sponsorship. Many employees are very interested in that, and it's important and beneficial to have a policy in place for green card sponsorship. So setting up a timeline for employees being eligible for sponsorship and setting those expectations up front. And then also just having clear onboarding procedures to kind of speed up the process up front to get the petitions filed, especially for a change of employer case, is important so that the individual isn't waiting too long to change employers and accepting another offer, deciding to stay where they are just because the process is taking too long. All right, last challenge is forecasting of immigration budget. There are a lot of costs associated with the immigration process. It is an investment when sponsoring a foreign national worker. So keeping track of renewal dates and forecasting green card sponsorship and timing can help with budgeting the year. And the immigration technology platforms such as Envoy can help with this process, as it can, again, notify you of upcoming expirations, suggest timing for green card, opening a green card, and giving you an overview of, costs and, how many individuals you have up for sponsorship or renewal that year. And also another solution is choosing an immigration partner that has flat rates, which can help you accurately plan the budget for immigration processing instead of dealing with billable hours, which can be a surprise. I think that's it for...
All right, yeah, those are a lot of, obviously a ton of challenges today and a lot of solutions that Jacqueline presented. So as we wrap up Jacqueline's main presentation, some key takeaways that we can pull from what she was saying. Technology can greatly simplify the immigration process. And obviously with H-1B cap season coming up, if you would like to learn more about how this technology can help you streamline and keep track of dates and deadlines and things like that, definitely reach out to Envoy, and we'll be in touch to show you that, and then and more. So Jacqueline, thank you for the great presentation. I'd like to ask a couple questions. We've been getting some couple questions that have been coming in throughout the presentation. But before I do that, I just want to share some education credits that everyone online can use. So you mentioned that obviously there's a ton of USCIS updates that are coming in from, what's the best way to keep track of those?
So the best way to keep track of those, obviously, is to speak with your immigration counsel. But again, having like a centralized immigration platform can kind of keep you and your employees updated on policy changes so those alerts can be, sent out efficiently. And then, obviously, it's reviewing the USCIS webpage, but that can be a little overwhelming and confusing because they don't delete old information when they update new information. So I'm really just keeping in touch with an immigration counsel to keep you updated with all of the changes and policies. Because some policies are more trends and they might not be official policies that have been implemented, but we notice a lot of trends with the USCIS adjudication that we try to inform. At GIA, we try to inform our clients of those trends that might not be official policies, but that we're obviously noticing as directives within the organization or within the USCIS or Department of Labor. Excuse me, I'm clearing my throat.
Right, thanks. So we're only a few days away from November, and H-1B CAT season, as I mentioned, is approaching. So the question is, what should we be doing to ensure a successful H-1B CAT petition?
I would say definitely, even though H-1B CAT petitions cannot be filed until the first week of April, to get a list of your H-1B CAT candidates early, get their job descriptions together, and open the cases with your immigration counsel as soon as possible, so that issues can be spotted up front, the LCAs can be filed early, so you don't run into any processing delays. The Department of Labor can get behind as we get closer to March with certifying LCAs. So I think it's important to just think about it early. Don't wait until March to open up H-1B cases or think about H-1B cases because it's better to be able to spot issues with maybe a weak job description or a salary issue, a prevailing wage issue, or other red flags that might come up about the employee's status that we'd have to address before filing. So yeah, earlier is better than later when it comes to the CAT.
Great. So you mentioned a weak job description. Are you able to say what makes a strong job description?
So a strong job description is one that has clear technical job duties. So I would say at least 8 to 10 job duties. It won't necessarily be the job description that the company would advertise, as you might have a more general job description that you'd advertise for the position. So it'd be more your internal technical job description. What exactly does this person do on a day-to-day basis? Especially for an H-1B case, it should outline clearly that the position requires at least a bachelor's degree in a specific field of study. So job descriptions would say, a bachelor's degree in business, science, arts. That's not going to be a strong job description for an H-1B case. A job description says, computer science, software engineering, or related fields is going to be much stronger. And obviously, when hiring, an H-1B worker, you'd want to think about their degree field directly matching the requirements for the position.
Gotcha. So we got some other questions coming in, and as we review them on our end real quick, I just want to remind everyone that if you would like to ask a question, please do so using the right-hand function on your computer screen. So this question that just came in, Jacqueline, do you recommend to file H-1B CAP immediately for fresh OPT? Fresh OPT have 12 plus 24 months STEM work authorization.
So I would recommend that just because it is a lottery. The H-1B CAP is a true lottery. I think last year, I need to brush up on the statistic, but I think it was close, close to 40% of petitions. I think 30-something% of petitions were accepted. The past few years, it's been around that, between 30 and 40% of petitions. So it is a true lottery. So if they aren't accepted the first year, you'd have another 2 chances if they're eligible for a STEM extension. So it's better again to file early in that sense as well. So they get as many chances as possible to apply in the lottery. It's just as a true lottery. They may be selected up front, and in that case, You could have the option of filing as a change or as a consular processing case instead of a change of status if you want to kind of reserve their H-1B time if they have OPT available. So that is kind of a strategy approach if you're worried about them kind of wasting their eligibility for OPT.
Gotcha. Also mentioning in the slide deck, expectations for hiring managers, creating an onboarding plan, and just telling them about that. So what can you? The question is, what expectations should we be setting for our hiring managers?
Again, I've talked to a lot of hiring managers and recruiters when working for some companies, and a lot of them just aren't informed about the immigration process and the timelines associated with that. So it's just important to make your hiring managers and recruiters aware of, the timeline for the process. So for an H-1B case, if you were to open, again, you're not going to, I think I mentioned this in the presentation, you're not going to be able to start that person the following week. You need to gather the documentation. The LCA needs to be filed, which takes about 8 days, sorry. And then the petition has to be filed, sent and received by the USCIS. So it usually takes, 2 to 3 weeks after the all that documentation is submitted to actually have a receipt from the USCIS, so that they can begin employment in a change of employer case. So just, setting the expectations like, okay, if you want to hire this person, I need their job description, I need their salary, I need you to contact them and get all the documentation that's required, such as education documentation, their maintenance of status documentation if they're currently in the U.S. in H-1B status or another status, and have that ready to go. And even after that, we probably have to set a start date for about a month out just to be safe so we can get everything filed. And that's in an H-1B change of employer context, which is most common. And then obviously, as far as if you're filing for CAP, you got to take into account if there's going to be any gaps in work authorization, because it is in April. We file in April, but it's an October 1st start date if they're selected and approved.
Gotcha.
I think I answered that one. Oh yeah, one was, do we file a consulate petition so that we can maximize OPT and STEM? Oh, I answered that in the first one. Yeah, so that is a strategy for an H-1B CAP case for someone in OPT to kind of preserve their OPT time. Again, is to file for consular processing instead of an automatic change of status. So that way, if they're approved, they would not automatically change from F1 status to H-1B. They could kind of wait it out and use some of their OPT time and wait to apply for their H-1B visa abroad to change their status.
Gotcha. Well, Jacqueline, those are all the questions that we have today. We're going to end things a little bit early, give everyone the line some time back into the day. Jacqueline, thank you so much for joining us for today's webinar. It was a great presentation. Everyone listening in, thank you so much for taking the time out to attend today's webinar. And again, the recording and the slide deck will be emailed out to everyone in attendance. So please keep an eye out on your email inbox for those links to download. Thank you, and have a great rest of your day.